So Brown versus State is another example of the distinction between using evidence as substantive evidence and as impeachment evidence. Under 613, the court obviously talks about the fact that we can bring in a person's prior inconsistent statements as impeachment, but the question is whether we're bringing that in as merely for impeachment, to tear down the witness's story, or to actually build up the prosecution or plaintiff's case. If it is merely to tear down, then that part of the story cannot form any part of the elements that are required to build a case, to prove the case. And so this comes up if the prosecution or the plaintiff needs that testimony to establish one of the elements. So in this case of Brown versus State, the only evidence that came in that implicated the defendant, or one of the key pieces of evidence that came in to implicate the defendant in this particular burglary of a drugstore, that piece of evidence came in by way of prior inconsistent statements that were not previously under oath. They came in merely as impeachment. And so very easy case, the court holds that without those pieces of evidence, the prosecution's case falls. And because those statements could only come in as prior inconsistent statements under 613 as impeachment, because not previously under oath, not in a preceding deposition, hearing, trial, etc., that those do not form fundamental building blocks that are part of the elements that the prosecution had to prove. And so therefore, without those pieces, there was an inadequate case against the defendant, and therefore the conviction has to be reversed. So the key takeaway from this is that if you have prior inconsistent statements, doesn't matter where they come from, you can get them in. But if you need those claims that are only in the prior inconsistent statements, if you need those to build the elements of a case, whether from the prosecution or the plaintiff perspective, criminal or civil, either way, the plaintiff or the prosecution has to build the case, has to prove the elements, then you cannot use prior inconsistent statements that are only coming in as impeachment to do so. And therefore, in this case, the conviction falls because this crucial element that established the defendant's guilt only came in as impeachment. They didn't have any affirmative substantive evidence to prove the case, and so therefore the conviction falls. If the defendant, either civil or criminal, is trying to bring in prior inconsistent statements, all the defense is ever trying to do is tear down the story. The defense never has to actually affirmatively build up the story. And so the defense will never, ever need evidence to come in as substantive. Impeachment works just fine for that purpose. You might prefer to have the jury instructed, no, this comes in for any purpose you want, as opposed to having the limiting instruction because somehow it diminishes the character of the evidence, makes it seem a little less important. But for all practical purposes, and truthfully, for any real way that a juror is going to be looking at this evidence, if you're on the defense side, you don't care if it comes in under 613 or 801D1A. You're just tearing down a case. You do not have to build a case as a defendant. So again, the takeaway here is this conviction falls because the only way that one of the key crucial ways of showing this case was proven was through prior inconsistent testimony that was not previously under oath in a deposition hearing, etc. And so therefore it does not come in as a prior inconsistent statement as substantive evidence under 801D1A.